topic that I planned on speaking to, I'll try to address to some extent here. And it is that I think most people in general don't understand historically what historically the role of the jury has been. But that applies in spades to most lawyers don't understand it, and most judges don't understand it. Because it isn't taught in law school. It isn't practiced in the court system. It isn't tradition which is honored. So there's a lot of misunderstanding and misapplications of principles and laws and rules in legal proceedings. And to answer Roger's question about who was the first person arrested for jury tampering, I have no idea. But one of the first person who basically was involved in teaching prospective jurors about their rights to judge the law as well as the facts was an Englishman named John Lilburn, who was prosecuted many times for many things, among which was advising jurors that they had the right to judge the law. That was part of his basically declaration of what the rights of Englishmen were, that they had the rights to judge not just the facts of a case, but also the law of the case. But if you go back to the early traditions of the jury trial, and even prior to jury trial, prior forms of trial in England, where we got our system, where our system evolved from, there's been confusion for centuries about the role of the jury, and it persists today. In the 1600s, when John Lilburn was an activist opposing first the Crown and then Parliament as their arbitrary powers, he proposed that Englishmen had basic fundamental rights. He drafted petitions declaring what those rights were. He circulated them among the people of London, the people of England. He brought them to the king, and he brought them to Parliament. And they said, who the heck are you? You don't represent anybody. You're advocating treason. You're upsetting the people. So they put him on trial for treason. And when he went to trial, they asked him to recognize the authority of the court. And he said, I don't recognize your authority. You're illegitimate. You're illegal. You're Norman pretenders. You're not English court. You've adopted the French law, brought into our country arbitrarily. It doesn't have anything to do with the rights of Englishmen. So he was a beneficiary of the fact that the printing press had been invented a few years earlier, and now books were being printed in English, giving the common people access to books about the law. Before, all the books were in Latin or Norman French, and only the educated people had any idea what was in the law. But he read the law for himself, self-educated, became essentially a pro se pain in the ass to the whole legal system in England for many years. Eventually he died in prison, but before that he won many important battles. And among the rights he demanded for all criminal defendants were the right to counsel, the right not to incriminate yourself, to be forced to incriminate yourself. He was opposed to the military draft, corporate monopolies. He was for universal suffrage, men and women. He advocated essentially most of our Bill of Rights. He was against cruel and unusual punishment. He proposed all these things in the law, in his petitions in the 1600s. And some of it was adopted by the British in the 1700s, and some of it was adopted by the America's founders, who all knew the history of John Lilburn. But his history has mostly been erased from law schools, and the only reason I learned about it was my client, Laura Kriho, found out about the history of John Lilburn, and she taught me, or showed me where the stuff was that you could read up on his history. And his history has become much more important in recent years. But at his trial, for instance, or multiple trials, the judge would instruct the jury that they are to find the facts, and the judge would determine the law. And it was considered a usurpation of power at that time for the jurors to decide, in some cases, the legal question of the verdict. They could decide the facts. Did this man publish this book which criticizes the king? But they couldn't decide if it was seditious libel. That was for the judge to decide. But it was recognized that if the jury did choose to decide the verdict itself, they were taking a risk. Because if their verdict was considered false, the jurors could be punished. If the jury brought back a verdict which the court found was false, they decided the issue, and they acquitted the defendant. But based on false verdict, according to the judge, they could convene another jury, a 24-person jury, to review the trial and see if the first jury erred. It's kind of like an appeal. And if they erred, if it was determined the first jury made a mistake, those jurors were declared infamous people. They were deprived of their homes. The trees were uprooted from their property. Their children were cast out. They were just treated like lepers and pariahs, and all for getting the verdict wrong. So from the very beginning, as long as there have been trials, there's been a tension there between what's the limits on the power of the jury and what's the proper role of the judge. It's never been settled. But jurors today are still told in almost every trial by the judges, you are the finders of fact. I determine the legal issues. If anyone here has a problem with that, speak up now as we're selecting the jury, because I'm going to have you take an oath that requires you to follow my instructions. If you don't do that, you could be in serious trouble. So jurors are basically told that they're going to have to follow the judge's instructions on the law even though they haven't heard them. And some jurors find this kind of dubious and say, well, I think I could probably do it. Again, sometimes they speak up and say it. When the judge says, can you follow my instructions on the law? Can you make that commitment right now? And they'll say, well, I assume so. And then that really upsets some judges. They get sensitive to that right away. What do you mean that you assume so? Well, I assume I can follow your instructions, Judge, unless you give me something that's really foolish and I know it's wrong. Well, then that person is thrown off the jury. They're not allowed to stay on the jury because they've evidenced an independent mind that judges are going to allow. So what actually happens in trials during the voir dire process, my description of it, is the beginning of the process of mind control. This is mind control exercised by the court designed to control the outcomes in the trial. And contrary to Mr. Roots, I disagree. I do believe that our legal system wants jury trials, has always wanted jury trials for a number of reasons. One is it legitimizes the outcome of the criminal case in the public's mind. It doesn't have to be a legitimate outcome, but it makes it appear legitimate to have participation of the community. You might glean from what I just said that I'm somewhat cynical about the system actually delivering on the promise of justice or concern about justice, and I am more than cynical. I think I'm just a realist. But I do believe that it's also long been the case that judges didn't want the responsibility for determining verdicts. They wanted to be able to blame the jury, but they wanted to also control the outcome. So they wanted the jury to reach the right verdicts, but then they didn't want to have to personally live with the verdict. But even though they might have to impose the sentence, they didn't want all that responsibility on themselves. So at least that's what's been written in the law books for centuries. That judges were happy to have juries decide the verdicts as long as they got the right answers. But if they didn't get the right answers, they wanted to intimidate, punish the jurors so that it wouldn't happen again. So they sent messages out. Some of the famous cases where courts tried to punish jurors, the most famous was probably the trial of William Penn, which I think was about 1680 in England, where he was charged with preaching an unapproved religion in violation of their laws. And the jury came back and wouldn't bring back the verdict that the court wanted. They kept coming back and saying, we can't reach a verdict, we can't reach a verdict. Judge wouldn't let him go home, so they finally said, okay, we found that he preached a sermon, but they wouldn't find that he violated the law. Well, the judges were quite upset, in a panel of judges. So they basically arrested the jurors and put them in jail until they would change the verdict and make it correct. And some of the jurors petitioned a higher court for relief, a writ of habeas corpus to free them, saying you can't lock us up and punish us for not producing the right verdict. And a case was decided, I think it was called Bushell's case. I don't know how his name is actually pronounced, that's how I pronounce it. And the court in England decided to determine that it's not appropriate or possible or allowable to punish jurors for their verdict. You can't lock them up, you can't punish them, you can't imprison them, you can't do anything. So if they do reach a verdict of not guilty, you have to live with it. The courts have to accept it. So since that time, that's really not been a question. And since roughly that time also, it's not been a question that jurors in criminal cases do have the right to determine verdicts. And a verdict is not a fact finding. It is not something that is simply a fact. A verdict is what the law calls a mixed question of law and fact. So when a judge tells the jurors, you are the fact finders and I determine the issues of law, he's lying or misrepresenting or misunderstanding, to be kind. Because the jurors are deciding a very important legal question. Is a person guilty? That's a legal determination. They're not guilty. They're not being asked, was the person on the street corner when the assault occurred. They're not being asked specific interrogatory kind of questions in most cases. They're not asked to produce a set of facts that they determined happened. But judges pretend that that's their role, and they mislead jurors, and they do it in the beginning when they give them the preliminary instructions. The chief judge in the federal district court here in Colorado tells the jurors, you are the fact finders. It's your job to determine what happened. It's my job to determine the law. It is not their job to be the fact finders and determine what happened. What their job is to determine what the prosecutor has proven beyond a reasonable doubt, to compare that with the definition of the crime, and see if what's been proven beyond a reasonable doubt meets the elements, satisfies all the elements of any particular offense. And then they're instructed, if they do find that, then they should, not must, but should, find the defendant guilty. But when I hear a judge tell the jury that they are the finders of fact, I want to stand up and object, but it's not considered polite to object to the judge. And they wouldn't know what to do except maybe have me arrested if I did it more than once. I'd say, I'm sorry, Judge, I didn't realize you were the judge, not the lawyer. But it's misleading. And then, because then they contradict themselves. You are the finders of fact, but don't visit the crime scene. Don't go online to see if you can figure anything out about these people in this case or anything about the principles involved in this. Don't do any research. You won't be allowed to submit questions. You won't be allowed to interview any of the witnesses. You won't be allowed to do anything, but you are the fact finders. No, that's just crazy. If they were the fact finders, they would be allowed to investigate the case. They would be allowed to ask questions of witnesses. They would be allowed to go out to the crime scene. They would be allowed to go online and try to figure things out. And what's really bizarre is when they're told, don't look anything up, don't do any research, don't talk to anybody about these things. Jurors who already know something that may be useful in evaluating the case are allowed to use what they know. But another juror who doesn't know something isn't allowed to look it up. So if I happen to know something about, let's just say, automobile mechanics, automobile engines or something, or a scene, a location where a crime occurred, if I happen to know something about it, I can tell the other jurors, and that's fine. But if I go out to the crime scene and look at it and come back and tell the other jurors, I've committed misconduct and I can go to jail. So if this, by accident, the juror happens to know something of use to the other jurors, they can share it. But if they go out and find it, they can be arrested and put in jail, thrown off the jury, cause a mistrial. So there's a lot of hypocrisy going on. But this originated in obscurity, this question about whether they are merely fact finders or also considered questions of law. But some people have now modified that argument over is to say that they have the right to determine not only what is the law, but what should be the law, or what should not be the law. In other words, if we find the defendant did all these acts, but we also find we don't believe this should be a law, a crime, we can vote not guilty. That's a form of jury nullification, which a lot of people, in fact, would define it as or describe it as. They judge the validity of the law itself. Or they could simply be determining, is this the law? The judge told us it's the law, we don't believe it, we think he made it up. They could be saying, we're going to reject the judge's charge on this definition of assault or menacing because we don't think he's right, we think he's mistaken. In fact, I've had jurors tell judges, if you make a mistake, judge, and we know it, I can't follow your instructions. I had a gun case in Denver where a guy deliberately went out and carried a weapon to challenge the law that made that illegal. And the judge knew it was a constitutional challenge, but didn't want anybody to mention the Constitution. Like Mr. Root said, you can't mention the Constitution. Well, the judge told the jurors it was going to be about gun rights. The case was. And then he asked, well, you all have any problems following my instructions? And one juror raised his hand where it was asked, and he said, I don't know, Judge. Well, what do you mean? Well, Judge, if you tell me there's no Second Amendment, I'll know you're wrong. And the judge threw him off the panel because he's obviously a person concerned about the Second Amendment and gun rights. He couldn't be on that panel. And the judge also told me that I was not allowed to mention the Constitution. So I thought that was kind of funny. I usually, if I mention it, I mention it as a generality. I don't argue specific principles or specific provisions, how they're interpreted by courts. I don't go into that with juries. But I do like to mention that there's a Constitution to protect my client's rights and their rights and all of our rights. But he said I wasn't to mention the Constitution in any respect during the trial. And then he asked me, Mr. Grant, do you understand my instruction? And I said, no, Judge, I do not. And he said, well, let me explain it to you again. If you mention the Second Amendment or the Constitution or anything like that, that's prohibited. Do you understand that? And I said, no, Judge, I do not. And he didn't ask me what my problem was because he didn't want my answer. But no, I never understood him telling me I couldn't mention the Constitution. I thought that was pretty obnoxious because he took an oath to uphold the Constitution, as I did, as anybody who's got a law license supposedly did, except for those who didn't take the oath. And there are some people who say that if a judge doesn't take the oath, or if he can't find a record of his oath, he's not a legal judge. There are inmates trying to get out of jail based on that argument. The judge can't prove he took the oath. But at any rate, there's a lot of history in juries. What happens in trials starts off with the judge and the attorneys eliminating jurors who have open minds, eliminating jurors who know anything about the history of the jury, about the rights questions. So a juror has a choice then of, do I deceive? Do I dissemble? Do I pretend I'm stupid? Or do I just speak up and say, yeah, I know you're full of crap. This is silly. You know, you're putting one over on these people and it's just wrong. Well, if they speak up, they're going to be removed and they can't do their job. But if you lie to the court, you're risking a perjury attack. Laura Kriho, the juror from Netherlands, was accused of contempt of court as a juror because she didn't answer questions that would have revealed. She didn't reveal during the voir dire process that she had certain attitudes towards the drug laws. She didn't believe that the drug laws were correct and that people should be sent to prison for drug problems. If they had drug problems, she thought they should get personal help. Anyway, she was also familiar with the Fully Informed Jury Association and their literature. So when the jurors were asked questions, they didn't ask her about her views on the drug laws. They didn't ask her about any associations with groups like FIJA. They didn't ask anything like that. And she was charged with contempt of court for not revealing during voir dire the answers to questions that were never asked. She was supposed to be forthcoming and let them know she was going to be a problem in this kind of a case, even though they didn't think to ask the right questions. So even if you don't lie, even if you don't hide the truth, they want you to know what you're supposed to volunteer, was the message in her case. And they prosecuted her because during the deliberations in her trial, not in her trial, in the trial when she was a juror on a drug charge against the defendant, she argued to the jurors that they didn't have to convict, that they had the right to vote not guilty for any reason or no reason whatsoever. And some of the other jurors thought that was seditious and that was disturbing. So they sent a note out to the judge, can we get rid of this juror? She's making arguments against the law. And the judge got upset when he got the note, so he declared a mistrial and asked the DA to investigate what went on in the jury room. And it turned out that Laura Kriho was the juror who was making these bizarre, to the judge, arguments. And she had also gone online to see what the defendant might be facing as a possible sentence. And she came back and told the other jurors, this girl could get 5 years in prison. I said, that's horrible. I'm not going to vote not guilty. And on the drug possession charge. But Laura also, and she was wrong in the sentencing, but people go online, they don't always get the right answer. But she also told them they didn't have to follow the judge's instructions. They could vote not guilty if they choose to. She was going to do that. But she also argued that the prosecutor hadn't proven his case beyond a reasonable doubt. Because you have to prove not only somebody's in possession of a drug, but that they were in knowing possession at the time. And the woman had actually testified in her own trial that she didn't know it was in her purse, that she was in a car with her boyfriend, and she thought that when they stopped, her boyfriend panicked and put the drugs in her purse. So Laura was also arguing the evidence. She was put on trial for contempt of court. It got a lot of news and notoriety, not just in the Denver area, but nationally and somewhat internationally. Went on for a few months. She was tried by a judge. She was denied a jury trial herself because they agreed to limit the punishment to 6 months or less, which doesn't trigger the automatic Sixth Amendment protection for a jury trial. So they deliberately limited their potential punishment to 6 months or less so they could deny her a jury. So a judge tried her. At the end of the trial, they had most of the jurors testifying, which is an important practice. they asked jurors to come and testify about what their deliberations were in the jury room, which is supposed to be sacred, confidential stuff, not inquired about, unless somebody's committing murder or assault or bribery or something like that in the jury room, but not about the deliberations. The jurors should never have to be forced to, under oath, under subpoena, to discuss their discussions. But she was convicted, but not immediately. The judge at the end of the hearing basically said, I'll take it under advisement. Well, that was pretty pathetic, because this is a criminal case. Juries don't ever take things under advisement and get back to you in a while. But he wanted to write an opinion, a decision, that would maybe withstand appeal. He wanted it. And he knew he didn't have the ability to write it, in my opinion. He wanted somebody else to write it for him. So he didn't announce his decision at the end of the trial. He said when he had his decision, he would give everybody notice to come back to court and he'd deliver it. It took him 4 months to reach a decision. It's the longest time of deliberation in Colorado criminal court history. The judge took 4 months to reach his verdict. And we appealed, and it went to the Colorado Court of Appeals, and they threw it out for some non-fundamental reason. It was an important reason, but not the most fundamental reasons. But the prosecutors wanted to use the prosecution of Laura Kriho to intimidate jurors, send a message. You can't go into the jury room and argue against what the court has said, or you'll be criminally prosecuted. They wanted all jurors to get that message. And they were, unfortunately for them, the opposite message went out, because Laura Kriho used this as an opportunity to educate the public about jury rights. And she brought up the history of John Lilburn and the jury rights movement that started 3.5 centuries ago in England and continues to this day. I want to go over just briefly, a few of the points, I think, that talk about the power of juries and the role of juries. You hear a lot about juries supposedly serving the function of being the conscience of the community. But how can they perform that role as conscience of the community if they aren't allowed to judge the justice of the prosecution? Not just the technical aspects of it, but the actual justice of it. And in England, for many years, felonies carried a very harsh penalty. Most felonies carried a death penalty. So if you're found guilty of a felony in England, the jurors knew it was the death penalty. If you're found guilty of a misdemeanor, you could get lots of lesser punishments. So when a person was charged with theft, if the value of the item stolen was found to be over a certain value, that qualified it as a felony. And juries knew that. So when they were asked to find, did the guy steal the horses? They would say yes, but they were only worth less than 3 pence, so the guy wouldn't be subject to the death penalty. So that was considered, by historians, that's considered a jury nullification verdict, because they basically found the guy guilty to a lesser charge, because they knew the more serious charge would carry that horrible, horrible penalty. So jurors exercised, they're called mercy verdicts also. They mitigated the the harshness of the law and the lack of discretion in the law itself by exercising their right to vote not guilty and not be questioned about it. Nobody can go to the jurors after they vote not guilty and say, how'd you reach that decision? That's a criminal offense, to go invade the jurors, except when the court doesn't, of course. That's basically a criminal offense. If the prosecutor would go to the jury and say, I want to know how you reached that conclusion, that would be a criminal invasion of the jury. So nobody does that. Sentencing information. Roger mentioned that jurors in the United States used to sentence defendants, so they knew what a person was facing, and they could exercise their mercy, their whatever, in the sentencing phase, because they were involved in this sentence, not just determining guilt, but also a sentence. But courts took that away. And there's always been this battle between judges and jurors about who's got the power to do what. What are the limits? Judges always want to restrict the jurors and use them for the purposes of legitimizing the legal system and giving it a good public image. But they don't want the jurors to go wild and think they're in charge. But in Tennessee, for a number of years after they eliminated jury sentencing, they had a law that allowed either side in a criminal case to instruct the jurors about the sentence the defendant was facing. Either side could request that instruction. The prosecutor could, the defense could. And the reason the defense would do it is to say, look, my guy's accused of this, what may appear to either be a minor crime, but he's facing 20 years in prison. They didn't want the jurors to underestimate the seriousness of the case. They wanted them to appreciate the seriousness of the case. And sometimes jurors with multiple counts to consider will try to decide for themselves what's appropriate, the lesser crime or the greater crime, in part in consideration of how much punishment it deserves. But they don't know the sentence, they're guessing, they're in the dark. They might think somebody's going to get probation, and the law might require them to get 20 years. And they would think, it doesn't sound like much of an offense, and they'd be wrong, because the law considers it a very serious offense. The courts who don't allow jurors to know that, in my opinion, make jurors unwitting participants in horrible injustice. If they, through their verdicts, authorize the court to sentence somebody to 30 years in prison for something the jurors wouldn't have wanted them to get more than 2 years, the jurors will have to live with that all their lives if they learn about it. If they were tricked and hoodwinked into bringing back the verdict, which punished somebody way more severely than they would have had they known otherwise. And other people will say, well, but that's the role of the jury. They're not supposed to be involved in sentencing. Well, no, that's the recent evolution of the law in most courts in this country, but it's not been the history of the law. And the Supreme Court, in fact, has recognized the history, this historic struggle over the role of the jury, the limits of their power versus the role and power of the judge. And they said basically, the United States Supreme Court has basically said, the rights of the jurors won out over the power of the courts to restrict them in these mercy verdicts. In a case called Jones versus the United States from 1999, Justice Souter wrote about it and said, and described some of the history where these English juries would bring back convictions on lesser crimes in order to give some mercy to the defendant. And they said the courts tried to find ways around that by limiting the jurors to just finding facts and let the judge pronounce the verdict, but it didn't work. The English law didn't accept that. The English legal system didn't accept that. Jurors were left with the power to decide verdicts, which is the ultimate decision that then empowers the court to impose whatever sentence can legally be imposed. But Souter said that history and the fact that the jurors' power was preserved had to have been within the minds of the framers of the Sixth Amendment guarantee of the right to jury trial. That was part of the history. That was part of the meaning of the right to jury trial that's guaranteed in the U.S. Bill of Rights. So that's what the U.S. Supreme Court has said about it, but they will also say out of the other side of their mouths, but don't tell jurors they have this power. And nobody should be allowed to tell them during trial that they have this power to do mercy or power to decide it's an unjust verdict or it's an unjust law. They shouldn't be allowed to instruct, or they shouldn't be allowed to talk about it. I had a case that I was asked to handle for another lawyer who lost a trial. He asked me to handle the appeal in the 10th Circuit here in Colorado. And I couldn't find any issues in the transcripts. It was a very weak lawyer. He didn't do a good job. He didn't do much of a job defending his client, and that's pretty typical, by the way. And it's for many reasons. It wasn't all his fault. But I found one issue in the transcripts, and that was I thought the judge had lied to the jury about their role. And it's what Mr. Root was talking about earlier. The judge, who was a very well-known judge, whose name I won't mention today because this could see the light of day, he asked the jurors, or he asked one specific juror, well, I have to ask you the same question I've asked another juror, whether you'd be willing to accept the law from me as I give it in the instructions. The reason he asked the juror that specific question was because he knew that juror was a law teacher, a law professor, not at a law school, but at another university. And he said, so I'm going to have to ask you the same question I asked another juror who was also an attorney. Will you have any problems accepting the law from me as I give it? And this prospective juror said, I don't know, Judge. That really sets him off. And the judge says, well, why do you say that? Well, something might come up that I'd feel very strongly about. Well, like what? I don't know, Judge. Well, you know it's your duty to follow my instructions. And the juror says, actually, Judge, it's my inclination to follow your instructions. It's not my duty. And then the juror explained to the judge, which is not usually a good thing, that the jury always has the power to acquit, notwithstanding the evidence. And the judge, he lost it at that point. And he said, that's not the law. You're removed. You may leave. Go collect your 10 cents for being here today or whatever. And then he told the rest of the jurors that that man was wrong. He made misstatements about the law. That is not the law. They could only acquit, he told them, if they found the prosecutor had failed to prove their case. And that is a total misstatement of the law. That they can only acquit if the government fails to prove its case. Nobody can ever tell the jury you can only acquit if. That is always misconduct, whether it's by a lawyer or by a judge. So I found my issue. I didn't think it was an issue that the 10th Circuit would like to hear. But it was the only issue I could find in the case, and they didn't like to hear it. And they said, I'm basically advocating jury nullification. They weren't going to have it. It wasn't the law. And the judge was right. I was wrong. And they were wrong. So I still know that they were wrong, and I think they know it too. But they weren't going to allow anybody to tell the jurors. But see, and I've had prosecutors make that same argument. In order for you to find, or a similar argument, in order for you to find the defendant not guilty, you would have to find that witnesses A, B, C, D, and E all lied. And I stand up and object. Objection. You can't tell the jurors what they have to find in order to justify not guilty. That's just wrong. They only, even by the court's instructions, they can only be instructed that if you find that all the elements have been proved beyond reasonable doubt, each and every one of the elements, then you should convict, not that you must. And they can't possibly say that they have to justify not guilty. That's reversing the burden of proof. You can only, if you find the government didn't prove A, B, C, D, and E, then you can vote not guilty. That's reversing it psychologically. That's reversing the legal burden of proof. And courts that don't understand that should be disbarred. Judges that don't understand it should be disbarred. And the district attorney in Denver should be disbarred for prosecuting people handing out literature on the courthouse lawn because he doesn't understand the First Amendment. And I don't think this is a deliberate plan to carve out an exception to the First Amendment for jury information. I disagree somewhat with that point. I think it's just simply a logical, natural progression of prosecutors doing whatever they can to eliminate things that bother them. I don't think it's a conscious plan to subvert the First Amendment because I don't think they have any clue of the First Amendment in the first place. So I don't think they're trying to carve out an amendment in the courts. And Roger's right. The courts aren't going to publish decisions that justify that kind of criminal prosecution. Or they don't. They're not going to establish clear precedents on that because they want it to go away. They don't want to have to address these issues. That's why in Laura Kriho's case, they didn't address the fundamental issues on the appellate decision. They addressed a technical question, which was to say that it sounded like Laura Kriho actually was participating in deliberations. And as long as she was possibly participating in deliberations, it would be wrong to invade the jury room and punish a juror for violating her oath or not revealing something. Now, other jurors have been prosecuted, actual jurors in criminal cases, have been prosecuted for lying under oath when they were asked a specific question and they lied about it. And those prosecutions have been upheld. But the one to intimidate jurors, as in Laura Kriho's case, have not succeeded. So I want to tell you a couple of other things. The Supreme Court has pointed out, again, Justice Souter in that case, Nathaniel Jones versus the United States, he pointed out that the founders and framers were very aware that the right to trial by jury could be lost by gradual erosion, by adopting practices which compromise the right to trial by jury, or minimize it, or reduce it. And I've come across quite a number of those. In one presentation I did a number of years ago, 10 or 12 years ago, in Philadelphia, I met a bunch of public defenders from the city of Philadelphia who were talking about jury nullification or how to encourage jurors to exercise their considerable power to vote not guilty for a lot of reasons, or in a lot of creative ways to communicate with jurors, to inspire them to vote not guilty in ways that might be somewhat sympathetic to jury nullification. And these lawyers said, well, we don't get much chance to do that. I said, well, why is that? I said, well, because we don't have many jury trials in Philadelphia. And I said, okay, why is that? Well, we have basically two paths in Philadelphia. You can send your defendant client down pathway A to the hall of trial by judge, or pathway B, which is trial by jury. I said, well, why would you choose trial by judge? I would never do that. They said, because that's a nice judge. If you send to trial by jury, that's a mean judge. So if you go to the jury trial and exercise your right to a jury trial, you get a hanging judge. So if you lose, your guy gets hammered. But if you go to this other path, you'll get a nice, reasonable, kind, gentle, lenient judge. So even if he finds you guilty, you're going to get a lesser sentence. So we understand that it's in our client's best interest to waive the right to a jury trial. And I said, do you understand that you're violating the constitutional rights of your clients, or that the judges are, by setting that dual system up to encourage you to give up the rights of your clients to jury trial? Well, we don't really know what the answer to that is. I said, well, you should file grievances against the judges who set that system up. Well, of course, the judges will never admit that this is a really harsh hanging judge. And if you go to the jury trial and lose, you're going to get hammered. But the lawyers all know it, and that's the way they conduct their practice. That's one.
I don't want to be rude and interrupt you, but we have like 15 minutes left, and I want them.
Okay, let me just do one or two other quick examples. In the District of Columbia, the lawyers practice something called stipulated trials, which is where the lawyers say, Judge, we the prosecutor agreed on the facts. We're going to give you the facts. We're not going to ask for a jury. You decide the verdict. So again, they've wiped out the right to jury trial. And lawyers think they're lawyers, and yet they've given up the right to jury trial for their clients. One final thing. In federal court in Colorado, if you think the legal system works, in federal court in the United States, let me back that up, 99% of the people charged with crimes in federal district courts are convicted. 95 to 97% of those plead guilty. The rest are found guilty at trial. Less than 1% of the people charged are ever acquitted. In state court in Colorado, I had probably 70% acquittals. In federal court, 0. Systems don't work.